Okay, we'll take up the next case of, hopefully pronounce this right, VARNADOE versus WASKEEN, LLC.
Good morning, Your Honors. May it please the Court, my name is James Roach. I represent Appellant CAROLYN VARNADOE in this matter. I would like to reserve 5 minutes for rebuttal, please.
All right, you may proceed.
Your Honors, I would like to start off with a little bit of context, then move to the history of how certain fees were charged to the lot owners in this community, and then move on to how we assert the trial court committed error. So Port Buena Vista, it's a mobile home subdivision located in East Palatka, Florida, and it was developed in the early 1970s. The original developers recorded a 3-page document in the public records, covenants and restrictions, to establish the framework for this development. And I'm going to refer to that document as the declaration. And per that declaration, there was a planned residential lot component and an independent recreational club that was planned to consist of a golf course, a clubhouse, swimming pool, and a marina. And this recreational club was to be operated by a separate company, and the membership in that club was to be by invitation only. The focus of this dispute will be on paragraph 13 of the declaration, which is the developer's attempt to establish a formula or fees that the developer could charge the lot owners in Port Buena Vista for a share of the costs of the common infrastructure, the roads, the common areas, and so forth. One thing that's important to understand is this is not a typical HOA in that it's not governed by 720. It's not structured like a modern homeowners association is. In a modern context, the developer would eventually give the common areas and assets over to the association. The association is comprised of members who are lot owners in the community. They vote on the board of directors. The board of directors establishes a budget, and they assess all the members proportionately. In contrast, the way this development was structured is the developer retained control of all the common areas, all the streets, roads, infrastructure, the other recreational club areas, the marina, the clubhouse, and the swimming pool. The developer retained control of that in perpetuity, which it was subsequently transferred as it was sold down the line. But that is how this situation is different from an HOA today. So the developer in this circumstance, Resource, the appellee, has complete control over all those assets. The recreational component of this development was ultimately unsuccessful, and the trial testimony indicates that it was due to lack of participation or lack of membership in this recreational club. A clubhouse was built, but it was subsequently demolished. A swimming pool was built, but it was subsequently filled in. All unilateral decisions of the property owner, the developer at that time. The golf course and the marina were never developed. So since development in the early 1970s, this recreational club property, street, pond, and the other areas were transferred several times. They were sold and otherwise transferred to successor developers, I will call them. And aside from the vacant land upon which those recreational facilities used to exist, the clubhouse, the swimming pool, from the record it appears that the only remaining property out there consists of a pond and the roads and perhaps some unspecified open areas. And I say unspecified because the declaration just vaguely refers to common areas, but it doesn't say that these are tracts X, Y, and Z of a plat, and there's no legal description on that declaration. So it's not clear what precise piece of dirt was intended to be those common areas. So there's also a rental section in Port Buena Vista. It consists of 15 properties that are owned by Resource and have been owned by the predecessor developers. But according to the record, they do not consider those to be part of the development, or at least they are not included within the cost share that the lot owners are charged to maintain those the common areas, the roads and pond and so forth. Now I'd like to talk about a little bit of the history of how those fees were charged to the lot owners. So we have 24 years in the record. Of course, the development has existed for approximately 44 years. But before Resource, the appellee, acquired the property, the record indicates that from 1992 to 2015, the lot owner's share of the expenses was calculated based on the increased cost of living, the CPI, or by mutual agreement between the successor developer and some of the lot owners. In 1993, one of the successor developers, the Weber Investment Corporation, established a lot owner's payment obligation or fee at $2,246.14 per month based on the cost of living increase. And that same letter in which Weber established that club,
From what year was that cost of living increase calculated? Do you recall?
it does not indicate what year that was calculated based on. The letter was a 1993 letter. So it doesn't actually list out the calculation. It lists two payment obligations. It lists the lot owner's payment obligation, and it lists the recreational club member's payment obligation. So it has two separately listed payment obligations, but it doesn't, in fact, it doesn't show the math, but it does say it's based on the increased cost of living. And I think it says at 3% or something like that, but it doesn't show its math.
One of the increases, though, if I'm remembering correctly, was calculated based on CPI, but was calculated from a year other than 1971.
Precisely.
Is that correct?
Precisely.
Which one was that?
That is what Resource has done.
Okay, which year was that? Which increase was that?
That was the most recent, which is the focus of this appeal, where it increased it to $39.43. That's where it applied a CPI calculation that we are arguing is not supported by paragraph 13 of the declaration.
The earlier increase to the $27, was that a unilateral decision by the developer, or was that by some type of agreement?
It appears that it was initially a unilateral decision by that developer, but the letter, which is the only evidence we really have of that, indicates that there was a discussion with the homeowners association, which again, that's just a voluntary association comprised of some of the members. All members are not mandatory members of that association per the declaration. So what I believe was the case was that the developer said, or Weber said, this is the fee based on 3% increased cost of living, and the homeowners agreed that that is the correct fee. So I don't know that they necessarily agreed that it's an alternative fee in that case. I think the homeowners association, according to the letter, appeared to agree that that's the appropriate charge under the declaration.
Let me ask you about paragraph 13. The top part of the paragraph says that the purpose of the fee is to pay for taxes, insurance, and maintenance. Would you agree with that?
Yes.
Okay, and then the bottom part refers to the $5 and refers to the CPI.
Correct.
What would happen, which is the more dominant purpose, if you would, if those were to conflict in any way? For instance, if taxes quadrupled and that, 1972, would that $5 plus CPI apply, or would the more dominant feature of that paragraph, if you would, be that the purpose of the fee?
I believe in that context, the developer, by the language he drafted in paragraph 13, limited the increase in fees. So while the taxes may exponentially increase, the lot owner's payment obligation would not correspondingly increase to meet that obligation. And
So even if the taxes couldn't be paid, then that wasn't the purpose of that provision?
So I don't believe the purpose of the provision was to require the lot owners to pay the full obligation of those, and I believe that is the case, as is reflected by the declaration read in its entirety, especially paragraph 14, which talks about the recreational club. See, when the developer drafted this, he envisioned this recreational club, this golf course, these amenities, and as the Weber letter indicated, even in 1993, they were generating some revenue or expected to generate revenue from that club. That club is back in the same area. They share the streets. That's how you would get there. They share the pond. They share that infrastructure. So it would make sense that why would you pass on the whole cost to the lot owners when they're this recreational club out of which the developer is, developing and benefiting from? Why would he get the benefit of charging all of his expenses on the lot owners who may or may not be members of that recreational club unless they're invited to be members of that club? So that club was by invitation only. So I believe in that context, Your Honor, if the tax is increased, that is a risk that the developer bared by drafting that provision in that way, considering that he likely anticipated that there'd be a successful recreational club sharing in those expenses. So then we go back to the next time that the fee was changed. So it was $27.14 from 1993 all the way until 2011. And in 2011, Sherry Keene, we'll call her a successor developer, she was a subsequent owner, Resource's predecessor owner of those properties, asked the lot owners to pay $30 per month. Just asked if they'd pay, and approximately 2/3 of the owners agreed to have paid that. Perhaps a novation, if you will, as to those owners who agreed to pay that increased amount. Well, when Resource acquired the property from Keene, it unilaterally attempted to increase the fee to $39.43, which is when the dispute, which caused the dispute. The testimony indicates that the figure that Keene helped Resource calculate that figure. So Keene, after selling the property to Resource, was hired by Resource to manage the property at a substantial expense. But she testified that that figure was calculated by taking the $27.14 and increasing it based on the CPI change from 1998. And that precisely is what I am arguing is not supported by any interpretation of paragraph 13. Paragraph 13 sets out the formula, one of its and/or options, very ineloquently drafted, but one of its options is to calculate it based on the percentage change from the year of determination, so today it would be 2018, divided by 1971, multiplied by $5. And here, they took a later calculated amount, $27.14, and applied the percentage change in the CPI from 1998 to 2014. And that is not supported, and that's not a calculation supported by paragraph 13 of the declaration.
Let me ask you this. Were there any other changes to the fee? Like, did it go up a slight amount every year, or was it just, you know, two changes over the course of the last 47 years or so?
So the record, we only have from 1993 in the record from the trial court. Before that, I'm uncertain. But from the 24 years of the record that we do have, from 1993 until 2011, it remained at $27.14 per month. Notwithstanding that, according to the trial testimony, previous developers had problems in meeting the expenses and so forth, and perhaps may have experienced some financial difficulty. But I believe that is evidence of how the parties interpreted that provision. If those prior owners believed that they could unilaterally increase the fee and pass on the cost to the lot owners, that would avoid their financial difficulties. They would have done that. But the very fact that Sherry Keene believed that she needed to get the owner's approval to increase the fee indicates that the parties, through their course of performance, interpreted that provision to not allow a unilateral increase of fees to meet the actual costs of all these expenses out
They
there.
could have done a unilateral increase consistent with the CPI index, right?
They could have done that.
Basis.
I believe that, yes, Your Honor, they could have done that. Why they didn't, I could not answer that question. Okay, so after increasing the fee, when Resource acquired the property, they began sending these property management reports out. There are two of them from 2015 and 2016 in the record. And here's where you see Resources conflating all the recreational club costs with the other common areas or lot owner costs. There is no longer delineation between the recreational club fees and the lot owner's fees because there's no longer a recreational club. So the developer basically is imposing any of the expenses that were previously recreational club fees onto the lot owners because they're the only ones there now. And you can see that is evidenced by the park management reports. In addition, Resources including several other categories of charges that are not included anywhere in the declaration, including its own legal fees for its litigation, substantial management fee. So after buying the property from Sherry Keene, he agreed to pay her a $2,500 monthly fee to manage the park out there. And again, if we're talking about what the common areas that benefit the lot owners are, it's a street and a pond. Now there's a rental section out there. Perhaps that was part of the deal. Clubhouse demolition expenses. Again, the clubhouse is clearly a recreational club property, and it's not appropriate. The declaration does not allow that charge, that category of cost, to be paid by the lot owners.
So, counsel, I just want to make sure I understand your argument. It sounds like you're kind of making a two-tiered argument. And correct me if I'm wrong here, but it sounds like you're saying, number one, paragraph 13 does not allow the appellee to increase the fee based on the actual cost of maintenance. Number one.
Yes.
First argument. Then the second argument it sounds like you're making is that even if paragraph 13 can be interpreted to allow the appellee to so charge based on actual cost, that they can't charge the full cost because the paragraph 13 anticipated other sources of revenue. Is that your second argument?
Yes, but to add to the second argument, Resources also charging other costs that aren't included within paragraph 13, former recreational club costs. So he's just putting it all in one bucket, and he's dividing that among the owners. So he's also including costs that aren't supported by the declaration to be charged to the lot owners, former recreational club costs. He's adding categories.
Because they're not maintenance of the common areas.
Correct. Correct. They're associated with former club property and individual investment expenses of resource as the developer, including, again, its attorney's fees, pest control expenses for the clubhouse, general office supplies. They're also attempting to charge late fees, which nothing in the declaration allows late fees to be charged. So yes, that is exactly my argument, Your Honor. In some,
Counsel, going to the first argument, I'm sure as you have, I've read paragraph 13 and sort of wrestled with it. What does that last phrase mean? What is your position? What does that mean? The cost recorded for the year 1971 increases.
Yes. I think anyone can only speculate as to what that means. There's no specific evidence of intent of the developer at the time of contract formulation, so we do not, there's no way for us to know.
What kind of costs would be recorded?
Precisely. So what we see here is redundant references to attempts to reference third-party indices or the value of the dollar, limiting benchmarks. So I believe that's another redundant attempt to reference some cost recorded, again, that's passive voice, recorded by some other entity. Which one, I don't know, because there's already imprecise reference with the U.S. Department of Interior.
You don't think that's referencing the costs recorded in the declaration?
No, because if it did, it would render all the benchmarks, all the attempts to reference the other third-party indices and benchmarks meaningless. The developer could have simply said, the lot owner shall pay all the associated expenses, proportionally pay all the associated expenses with the common areas, and then ideally it would list what those areas actually are and precisely define them. It wouldn't need to reference any limiting benchmarks if all those costs could be shifted on the lot owners. And that brings me back to the recreational club dynamic, which is very important to understand.
Let me mention, you're at 3:40. I don't know if you want to save any time for rebuttal or if you want to continue on.
I will save the remaining time for rebuttal. Thank you, Your Honor.
All right, thank you.
Good afternoon. May it please the Court. William Earnshaw on behalf of the Applee Resource Development Group. I want to clarify a few things that, first off, that much of the argument that's included in the briefs and also that's been made by the appellant in this case is based on somewhat speculation, is outside of what's really in the record. There was a trial in this case, and there was no actual evidence presented at the trial about the purposes of the recreation club as being contributing to the cost to maintain these common areas.
Well, there was a planned recreation club, correct?
There was a planned recreation club.
And was it expected that the recreation club would have revenue?
It's not clear in the record that they did charge to.
How about the golf course? Was it intended that the golf course would produce revenue?
There's no record. There was no golf course ever created. There's nothing. But
it was
in the
anticipated,
record.
Correct?
It's listed in the declaration as the intention is to one day have a golf course.
And if you're building a golf course, is there not an expectation of revenue?
There could be, but there's not an expectation based on just the document that the golf course would also impact the common areas.
How would people get to the golf course without going through the common areas?
Just geographically.
Based on the record, how would they access it?
The record, you cannot tell where a golf course would be on this parcel property. There's not room for a golf course. It would have to be a completely separate parcel that would be apart from what actually the development of Port Buena Vista is. So
it wouldn't have been a part of this development, according to the declaration?
The declaration is very difficult to decipher what exactly would apply to what, but there's, based on the actual what was constructed and sold and what lots are out there, there is not a place for a golf course that would impact the areas that are deemed to be the common areas.
And I'm just really asking about what the declaration anticipates.
Right. In the declaration doesn't make clear. What the declaration does state is, and what does make clear is, this paragraph 13, that it's the purpose, the intention is to maintain roads, other common areas, which based on the record includes, there is a marina area that has kind of boat dock area. There's open grass area. There are the roads, And there's reference in the
Could the
record.
marina be a cost recorded for the year 1971, recorded in the declaration, in other words?
I'm sorry,
The marina, this last phrase, costs recorded for the year 1971. What are costs recorded for the year 1971? Are those the common areas that were recorded in the declaration, when the declaration was recorded?
The interpretation that we advance and that the trial court ruled on and agreed with was that the costs recorded for the year 1971 included what those actual costs would have been to maintain.
But it doesn't say actual costs, right? It says costs recorded. What does costs recorded mean? It doesn't say actual costs.
Right.
How do you, what's a recorded cost?
To be honest, that's the whole problem here.
How about a cost that was recorded in the declaration, when the declaration was recorded?
There are no costs recorded in the declaration.
Is the marina a cost?
The cost for the upkeep of the marina is a cost, yes.
So your definition of cost would be the maintenance of the marina, not the marina. The marina wouldn't be a cost.
Correct.
How about the roads? Would the roads be a cost?
The cost to maintain and upkeep the roads would be a cost, yes, as well as the taxes on those areas as well. And I think I want to get to...
So what about the golf course? Would that be a cost in the declaration?
If the golf course existed, it would not be part of the common areas. It would not be a cost. No.
Maintenance of the golf course wouldn't be a cost?
Correct.
What about the recreation club? Is that maintenance of the recreation club, is that a cost?
Under the declaration, it's somewhat unclear what is actually defined by it, but it would appear that the recreation club would be a separate one that would not be open to all members, so would not fall under what would be considered for paragraph 13, no. But in this...
But under paragraph 13, what were the costs that your client was incurring, whether it's $29 or $37, what was it covering? It was covering taxes.
It was covering taxes. Yes. It was covering maintenance of the lawn maintenance of the area, the pond maintenance area. It was covering the insurance on it. There are permit fees that are required. And so that... so it covered all those costs as well. There are within the record a list that was referenced by appellant's counsel, but that actually goes on. The $39.43 figure is not obtained actually by putting all the costs that are listed on those sheets and then dividing them like you would do with the homeowners association. It's actually a much higher figure, and the $39 falls within that. If I can kind of put a little context on this case was originally brought by appellant as the plaintiff, and the entire case from complaint through the trial, appellant's argument was that this language is unambiguous and that the clear language and clear intent is that the CPI calculation, that $5 as of March of 1971, calculated under the Consumer Price Index, is the only figure, the only way to calculate the proper assessments. That was through the trial, that was their entire argument. On appeal now, they've conceded that actually it is not unambiguous, that it is ambiguous, and that you have to, and that the trial court did not consider, it erred by not considering the course of performance evidence. That's what their argument is. The trial court actually did consider the course of performance, and Your Honors hit on this earlier, which is that there is not a single instance in the record where that $5 times the CPI calculation was actually ever assessed since 1993. The $26 that became $27.14 as of 1993 was another figure that the trial court posited that may have been the basis, the cost being higher may be the basis of why the amount was higher than what the CPI calculation would have been at the time. The $27.14 remained in place all the way to 2014. There were some voluntary contributions to bump it up to $30 because the cost increased. But the record shows that for the next 21 years, it remained constant, even though the cost increased significantly to maintain these common areas, and that the owners of the common areas faced bankruptcy, personal foreclosure, and could not pay up to the taxes, to where there was a $100,000 tax bill that became due. The trial court correctly, when in interpreting this, looked at what's the purpose of these assessments. It's to preserve, upkeep, maintain these common areas, and there's no logical link to a consumer price index to what actual costs of maintaining these common areas is.
Let me ask you this. The
Yes.
trial judge found that, one, he interpreted paragraph 13 and said that the only reasonable interpretation is actual costs. And then he made a finding as well that, that fee was justified by the actual costs. I mean, it's kind of two findings. Would you agree with that? Or two
That is
determinations?
correct.
What is our standard of review on each of those questions?
I believe that since the appellant has conceded that this is an ambiguous provision and has asked this court to review the course of performance of what the parties had done in the past, and has conceded that the trial court reviewed and was heavily reviewed the course of performance of the parties, then I think as long as there's substantial competent evidence in the record for the trial court to make the finding that the costs were, that was the correct decision, that is the proper standard of review here.
Where's the evidence in the record that prior increases were based on the actual cost?
There is testimony of Sherry Keene that she asked for voluntary increases because of that.
Those were voluntary increases
Right.
that not everybody did. So assuming for a moment the panel doesn't think that one gets you there,
Sure.
what's the other record evidence that you would point us to?
There's the only other evidence is the 1992 letter and the 1993 letter.
And wasn't there some indication in the record that there was an actual dispute between the developer and the HOA back then?
Correct.
And that
It appears that,
the amount they reached in 1993 was sort of a compromise between the two?
correct.
So how is that substantial competent evidence that the 1993 increase was based upon the actual cost?
There is not, that is a presumption you have to make as to what would that disagreement be, and the fact that
We're going to speculate as to what the disagreement was and what the resolution was?
Just the fact that the actual amount that was agreed to and that was charged and then increased by CPI from that point, that was significantly higher than what CPI would have been in 1993.
Well, maybe it was, but the record reflects that there was a dispute between the two parties and that they reached some form of
Right.
compromise agreement. But where's the record that compromise agreement was, we will base the increase on actual cost? Is that in the record?
That is not in the record, no.
Where is the substantial competent evidence in this record that the cost increases have ever been based on actual cost?
There is not evidence of that in the record. Just like there's not evidence in the record that the CPI calculation that is being proposed of taking $5 as being the sole true basis for the calculations, there's no evidence in the record that has ever happened. And all of the record evidence is that it has been higher than that. The evidence that's in the record is that in every instance where the amounts that are charged, which would include the amount proposed by appellants of $29.37, results in the common areas not being properly maintained. The appellants didn't testify, but a fellow plaintiff testified, two of them, And they both conceded that for the common areas, the amounts charged that are being sought in either of these amounts was insufficient to properly maintain the roads, properly maintain and upkeep the marina area, properly cover all of the
Is
expenses.
that sort of a second basis for the holding? There's number one, the trial court's, your position would be the trial court's decision is supported by the course of dealing, and separately it's also supported by the fact that the common areas cannot possibly be maintained under CPI increases. Two separate arguments there?
Yeah, as far as the course of performance argument, our argument.
I'm just asking, are you making two
Yes.
separate arguments? Are those alternatives to each other? I'm asking you to clarify your argument.
Right, sure. And our argument is really not so much built on the course of performance. It's really that's more of rebutting what the appellant's argument
The trial
is.
court looked at course of performance, correct?
The trial court did look at the course of performance in the sense of that the amounts that were charged were insufficient to actually cover the expenses, and that the overwhelming evidence was that it is far too low to what the actual cost would be.
Are there any common areas that were anticipated in the declaration that no longer exist today, that never happened or have been torn down or anything?
The common areas is described very vaguely in the declaration, and it's essentially, it names the roads and the ponds, but it also says the areas that are to be used in common by the owners, by the lot owners. So there's not any that is reflected in the record or that I'm aware of that existed at one time that no longer exists.
Or that were anticipated to exist and never
Right.
don't exist?
There's nothing in the record that would show that, no.
Let me ask you this, as far as course of performance, I mean, they're arguing, start with 5% and do the CPI index. That didn't happen. And then you're arguing actual costs, but that didn't happen either.
Correct, yeah. And so that our position is that because this is vague, that the proper analysis is to look at what was the intent of the developer in drafting this.
Yeah, so arguably there would, those would be the two most logical ways to interpret that provision, and yet the parties did not follow either of those interpretations as far as course of performance.
Correct. And that if you were to look at the course of performance, to the extent that is, then we would argue that the course of performance goes back to the only thing that really is in the record where there was an agreement based on the 1992 agreement of this is the new amount, increased by CPI from that point forward.
Is the amount that you assess.
And then that's what was attempted by the
Appellant
previous-
argues there's, under any reading of paragraph 13, that calculation is not supported by any reading of paragraph 13. Do you agree with that?
That which interpretation?
That taking the 1993 number and doing the CPI calculation from 1993 isn't supported by any provision in paragraph 13.
What it would require is that there was an actual agreement that we don't have any record
And
of.
that's not in the record.
And that's not in the record.
So it didn't happen as far as this court is
Correct.
concerned.
And so in the sense of what the correct amount is, the plaintiff's complaint was for declaratory relief saying that Resource Development Group and its predecessor violated the restriction, violated paragraph 13 by charging the $39 level. If the proper amount, which the trial court found that this was what was charged, the $27, even the $39, was insufficient of what the actual costs are, then as long as the true amount would be higher than that $39, that the burden is on the plaintiff to show here's what the proper amount should have
But
been.
that's assuming actual cost is a proper
Correct.
way to increase. So let's not get the cart before the horse. I mean, I hear what you're saying. If actual cost is a proper method for increasing the fee, then what you just said seems to be correct. But we're still trying to determine, as far as I'm concerned, what's the proper method for increasing the fee.
Right.
And you said there was course of conduct, but we've established there was no evidence at trial
Right.
to establish that. So what's the other argument that actual cost is what we should look at?
Because that's the only reasonable, logical interpretation based on contract interpretation rules, based on this court's prior rulings, is you would look at what was the intent.
What does the cost recorded for the year 1971 increases mean? Because one of the things we're supposed to do is to give meaning to every provision. So what does that provision mean?
Our position is that it means that the actual cost of maintaining what that is, whether it's recorded in the developer's maintenance ledger of what the actual costs were at that time, we don't know. We don't have that.
Well, this paragraph uses the term recorded more than once, and in the other place where it uses the term recorded, it's in an official type recording.
Right.
So same term. So what if this panel decides that the word recorded has some sort of official meaning to it? Where are the costs recorded? If we're not just talking about in a ledger or somewhere unofficially.
And there is no answer to that. That we don't know.
Well, the declaration was recorded, correct?
Declaration was recorded.
And the declaration would have had facilities that would cost money to maintain, correct?
There's no defined facilities or legal description or
Streets,
anything.
lakes, and all the grounds that are to be used by all the lot owners. That's the definition, right?
Correct.
So there is a definition.
But I'm saying there's no definition as far as a legal description of this particular property, what the cost was to maintain that particular property. So I'm not sure I understand Your Honor's question.
What if, let's go back to 1971 or 2 when this declaration was recorded. What if the community decided to make a new common area facility that wasn't anticipated by the declaration? Could that be what this last phrase is talking about? They decided to build a Olympic-sized pool, wasn't anticipated in the declaration.
Our interpretation...
Would that be an increase above the cost that's recorded in the declaration?
I do not believe so, Your
Why
Honor.
not?
Because I believe that what this refers to is whatever those common areas are, since they're not specifically spelled out by a legal description or a particular party, it's to be whatever those common areas are. And if there is an addition to those common areas, then again, it would be what those costs recorded. That's the whole problem with this, is that it's so ambiguous you can't pin down a particular number of what exactly this meant.
All right, your time is up, sir. Any other questions from the panel? No, sir. All right, thank you. Mr. Roach, let me ask you something. Did we basically have the same dispute back in 1993 where they're asking for costs and you're asking for the 5%, and then you all came up and there was an agreement for some number?
We only have limited information in the record, but I believe that the paragraph 13 establishing the baseline for increases by tying it to the CPI is what incentivized the parties to negotiate any fee at all. Otherwise, if any party interpreted that last clause of paragraph 13 to allow the developer to unilaterally increase those fees, there would be no reason to negotiate. He would simply say, here's what our costs are this year, pay your proportionate share.
So you have this number that's reached in 1993, and the number now, am I correct that number is based on the CPI index increase from 1993?
It is actually based on the CPI index increase from 1998. So the original amount was established in 1993, correct? But the CPI calculation was from 1998. And we believe that's not supported by paragraph 13. It must be from 1971 and multiplied by $5.
But if you reached a modification in 1993, should we give that weight in any way? I mean, it's got to mean something.
I don't believe that there was a modification to start applying that number prospectively to the CPI calculation. I think they said, well, here's the CPI.
Well, that number in 1993 was more than a pure CPI index from 1971, right?
I believe that would be how the math would work, yes.
Okay.
And I believe they agreed to pay
So
more.
do we ignore that fact, or do we? How do we take that into account?
I think one way to take it into account is from that point forward, that operated as a novation, and that the parties must mutually agree on the fees prospectively, because they reached that fee by mutually agreeing in that circumstance.
Right, but since that time, they've applied the pure CPI, correct?
Only in one occasion.
So I'm
and
trying to
that's-
figure out how you want us to give weight, or how you want us to factor in that agreement in 1993, because it almost sounds like you want us to ignore it because you want to just go back and say 5%, start at 5% or $5, I'm sorry, and then just do CPI from 1971. Now, to do that would mean that we're giving no weight at all to their agreement in 1993.
I don't believe it's not giving no weight. I believe what that is evidence of is the parties have only changed or derogated from that CPI calculation when they mutually agreed to do so. So unless they mutually agree otherwise in the future, the CPI calculation, according to paragraph 13, is their baseline. That's what they must go by unless they happen to voluntarily pay more, which occurred again when Sherry Keene asked them to pay $30.
Counsel, below you argued that this last phrase in paragraph 13 was not ambiguous. On appeal, you have argued that it is ambiguous.
I don't.
Correct?
Trial counsel, I do not believe trial counsel specifically argued that it was unambiguous. I believe what he argued was unambiguous is the CPI calculation factor, which
I understand, but nevertheless, on appeal, you're conceding that that phrase is ambiguous.
I think that's characterizing it politely.
If the panel were to disagree, are we bound by your concession then?
Were to disagree that it is ambiguous,
Correct.
if this court were to...
Are we bound by your concession that it's ambiguous? Is this the question? Simple way to say it, I guess.
No, it's de novo review. I believe this court could say, no, there should have applied the plain and ordinary meaning, and it did not. I don't think that's the right way to go, but that is within this court's authority to per de novo review, interpret it in a different manner.
All right. Thank you, sir. Your time's up. Any other questions from the panel?
No, sir.
All right.
Thank you, Your Honors.